Good afternoon and welcome to the City Club of Cleveland. I'm Hugh McKay, former president of the board of the City Club. Our system of electing judges has long been the subject of much controversy and debate. While electing officials works for many public offices, voters for judicial candidates often have little knowledge of the candidate's qualifications, and voters often cast their vote for judge based on name recognition or names that sound most familiar, perhaps, or based simply on party affiliation. This is an issue that has received much attention far beyond the state of Ohio. It's been the subject of stories in the press across the nation and fodder for advocates of good government and judicial reform groups across the country. Here in Northeast Ohio, the issue has inspired the Cleveland Bar's acclaimed Judge for Yourself program, a rigorous evaluation and rating system to help voters assess judicial candidates, as well as the Cleveland Metropolitan Bar Association's Task Force on Judicial Excellence. And I would note Jim Robenall, John Lyken here from the bar today, who have helped lead that charge. These issues are also a concern of today's speaker. We are delighted and honored to welcome Maureen O'Connor, the Chief Justice of the Ohio Supreme Court. Chief Justice O'Connor is the 10th Chief Justice in Ohio history and the first woman ever to hold the top position in Ohio's highest court. Chief Justice O'Connor joined the court in 2003. In her November 2008 re-election, she carried each of Ohio's 88 counties. Her distinguished career in public service spans 3 decades and includes service in private practice as a magistrate, common pleas judge, county prosecutor, lieutenant governor, and justice. She was raised in Parma and Strongsville and earned a BA from Seton Hall and a JD from Cleveland Marshall. Chief Justice O'Connor has received awards and honors truly too numerous to mention for her professional achievements. Since being sworn in as Chief Justice, she has pursued an extensive agenda for strengthening the judicial branch of Ohio government in a number of key areas, including the budget, diversity, community involvement, internal efficiencies, continuing legal education, commercial dockets, and impartial courts. Chief Justice O'Connor has been in the news most recently for her proposal to reform judicial elections in Ohio. This past May, she put forth an 8-point plan to reform Ohio's courts, and we expect that she will discuss that with us here today. The City Club is pleased and honored to welcome Ohio Supreme Court Chief Justice Maureen O'Connor.
Thank you, Hugh. Thank you, Hugh. Thank you very much for that introduction and for the invitation to speak to the City Club today. I am very honored to be here. I am very privileged to be here. My predecessor, the late Tom Moyer, spoke before the City Club on several occasions on the issues of justice and fairness within our judicial system dating back to, I believe, to 2001. So I stand in good stead, and I thank you for being interested in topics of the judiciary for these many hundred years that this organization has been in existence. And today's topic is, I think, in keeping with what my predecessor was deeply involved with and very much interested. We do have some divergent of thought, though, because the late Chief Justice was very much interested in merit selection. And while I acknowledge the benefits of merit selection and some of the negatives to merit selection, we're not here to talk about merit selection today. We're here to talk about reforming the system that we have, and I'm going to get into a little bit why that is important that we do that and why we're not going to talk about merit selection. You know, when I told folks that I was coming to the City Club, everybody is always very impressed because of the reputation of the City Club. And I think that's because everyone recognizes that the voices of reason are few and far between in the world in which we live today. And this organization, I want to take the opportunity to thank you for steadfastly holding on to and promoting the principle of discourse. We can get nowhere in advancing the agenda, the social, political, and humanitarian agenda that we need to address unless we have civil discourse. In a constitutional democracy, the judicial branch, of course, is a bedrock institution that resolves disputes, ensures order by adjudicating criminal offenses, and protects the rights of minorities and the rights of individuals. Judges are the officials in whom we trust these awesome responsibilities. Thus, there are few matters more important in our democracy than ensuring that we have a system in place that results in the best possible men and women serving on the bench. We enjoy one of the best systems in the world. Extraordinarily talented and hardworking people make up the Ohio judiciary, and the work they do every day is remarkable. And we have judges in the audience today, and I'd like to say thank you, ladies and gentlemen, for what you do. But there are three reasons that I think that we can do even better, and they are that the polls show that the public views judges as susceptible to political influence. The view that a judge is susceptible to any influence is unfortunate, but the view that that a judiciary is susceptible to political influence is particularly troubling. Another reason, voter participation in judicial elections is, on the average, 25% less in races than for the executive or the legislative branch. And that is a consistent figure. In some jurisdictions, such as Cuyahoga County, my understanding is in 2012, 40% of the folks that went to the ballot, took a ballot and returned a ballot or went to the polling places, 40% did not vote for members of the judiciary. There is evidence that we can do more to educate and inform the electorate, and that is also a reason for this reform of the judiciary. Judicial elections have been a matter of controversy in Ohio since they were first established by the Constitution of 1851. Over the last 75 years, there have been multiple attempts to do away with judicial elections entirely in Ohio. And voters, each and every time, have reaffirmed by very large margins that they want to elect their judiciary. Most recently, as I said, in December, there was a poll that found that more than 80% of Ohioans oppose doing away with competitive elections for the judiciary. That's an interesting percentage, and it's an interesting statistic. I wonder if those people knew that in the ballot of 2012, 2/3 of the judges that were on the ballot statewide were unopposed, whether they would still believe that the vote is that important when it comes to the judiciary. And then you also look at the fact that 50% of the judges who are currently judges achieved their first position on the bench by gubernatorial appointment to fill a vacancy. Those are, that's a bit of information that I don't think is widely known or widely understood. So anyway, I believe it's time to move on from judicial selection and talk about what we can do to strengthen the existing system of judicial elections, because elections are here to stay, at least for the foreseeable future. And that's why I announced in May, Ohio Courts 2013, an 8-point plan to strengthen judicial elections in Ohio, to empower Ohio voters, and to support the highest quality judicial candidates possible. The plan identifies a series of issues and poses questions surrounding specific potential reforms for public consideration. Let me take each question individually, and I'm going to explain a little more about them. The first question: should judicial contests always be placed at the end of the ballot? Think about it. Why are judges always at the end of the ballot? There's no good reason. I've asked the Secretary of State, I've asked, local boards of elections, I've asked local chairmen. There is no good reason except that they're nonpartisan elections. And that is the only rationale I can understand, or that I get. Ohio election law places judicial contests at the bottom of the ballot, and multiple studies demonstrate that ballot order matters. Candidates listed first get more votes. That's just a simple fact, and nobody argues with that. Contests and issues listed first get more participation. That is shown time and time again. In recognition of this well-documented phenomenon, Ohio law already mandates that candidates' names be randomized within the office that they are seeking. So should a similar approach be applied to the order of the contest? Because judicial contests come at the end of the ballot, as I said, 1/4 of the voters don't participate in these contests. There's a name for that. It's called ballot fatigue, and I didn't make that up. That is an actual term that is used to explain why voters don't go to the end of the ballot. Now, I think, when it comes to the judiciary, there's some very legitimate reasons why they don't. In their minds, they don't know enough about the judiciary, and I'm going to talk about that in a minute. So here's the next question. Should all judicial elections be held in odd years? Right now, we have municipal and county judges held in odd years, and in the even years, we have the Common Pleas Court judges, the appellate judges, and the Supreme Court. As an alternative, or possibly in conjunction with the first idea that I mentioned, what if elections for the Supreme Court, the appellate, and the Common Pleas bench, and the county courts were held in odd years like those for the municipal courts? During presidential and midterm elections, races for the judiciary just get lost in the shuffle. And that is true no matter what jurisdiction you are in. I had a conversation with Dan before we started today, and I said the last time I was at the City Club was when I was in a debate in 2008, when I was running to retain my seat. And I was here for a debate with my opponent. And when I ran for Supreme Court Chief Justice, there was no debate at the City Club for the Supreme Court. There was no debate for my colleagues in 2012 when they were running for the Supreme Court in 2012. The judiciary gets short shrift, and that's just the way it is, and the focus now is what can we do about it. Would separate dedicated elections for all judgeships receive the attention of an independent branch of government that it deserves? And I believe it would. We wouldn't have to compete with the presidential. We wouldn't have to compete with the gubernatorial or the other statewide, the legislative races, the congressional races, the senatorial races. None of that would matter when it comes to a judicial race. And the judiciary then, hopefully, from the Supreme Court down to the municipal court, would be the most, would receive the requisite amount of attention. We'd be able to showcase the candidates, showcase what judges do, showcase the importance of the judicial elections, and get more information to the voters, which I think would help cure that I don't know who to vote for, so I'm not going to vote, and we would see, I think, an increase in the number of people who participate. Would voters benefit by knowing that all judges are on the ballot at the same time instead of some during the odd years and some during the even years? I think so, because I don't think voters can keep track of that. They can't keep track of when the judges are up. I get the question all the time during an election year, even in an odd election year, are you on the ballot this year? Folks just don't concentrate on that, and I think that there's a better way to showcase the third branch of government. The third question, should Ohio centralize and expand its civic education programming and institute a judicial voter guide? I'm all for that. I believe that citizens routinely show that they don't know, their knowledge about the judicial system is wholly inadequate, and voter participation and engagement in judicial elections is less than in elections for the other two branches. You know, when you think about it, there really is little excuse for not knowing everything there is to know about candidates, not just judicial candidates, but the candidates for the other offices as well. You have 30 days to vote in Ohio. There's plenty of time for citizens to perform research about the candidates, and certainly plenty of time to perform research about judicial candidates. I always joke that you could look online, you could have an election party in your living room, you could have folks at the kitchen table, somebody could have a laptop, you could be looking up these names, you could Google them, you could go to their websites, you can look at the endorsements that are given out from the Ohio State Bar to the Judge for Yourself to all kinds of organizations that weigh in, and become an educated voter when it comes to the judiciary. Voters spend more time researching what kind of shoes to buy online than they talk about, how to vote, how to research, the candidates, and it's there. It's there at your fingertips. Now, there's also the thought that we should have a statewide judicial voter guide, and I'm a big advocate for that, because I think that we should have a one-stop shop that would be at the Supreme Court website, potentially, and we would have uniform information about each candidate, and the public would know that they can go there to start their research, and then we could have links to the candidates' websites, we could have links to the organizations that endorse, to the Ohio State Bar Association, to newspapers that endorse, to whatever League of Women Voters, their information is important as well. So, in this day and age, the way people use the internet can be a real tool of education for the judiciary and also for other candidates as well. But I'm particularly interested in the judiciary right now. You know, there's multiple success programs for general civic education in the law, and it's been suggested that these efforts would benefit from working in concert with one another. And I think it is important that we educate the public, not just about the candidates, but you know, it's important to educate the public about what judges do. There is such a misperception about the omnipotent judge, that the judge can do anything they want with the stroke of a pen. And there's also a misperception about what a personality or what the demeanor of a judge should be. And I could probably stand up here for another half hour and rail against the afternoon judge shows and the evening portrayals of judges and that sort of thing, because I think that's largely responsible for a lot of the perception that is out there about the judiciary, especially when you think that young kids come home from high school or grade school or whatever, and they flip on those ridiculous afternoon judge shows, and they get an impression of the judiciary from those shows, and it is so wrong. You know, our courts are open to the public. If you're if you want to see a judge in action, go down to the courtroom, go down to the courthouse, and encourage these kids to do it. We bring students into the Ohio Supreme Court every time we have oral arguments to try and educate them. We have a wonderful education opportunity for kids that tour our building, and we also take our show on the road twice a year. The Supreme Court goes out into the communities and interact with high school students, and you know, I'm just all for the judges encouraging involvement and participation and presence in the courtroom so that the average citizen can see what the judiciary does. You realize that we're limited by the Ohio Revised Code and so many other rules and precedent. You know, I love that because we make precedent, you know, on the Supreme Court. We're, you know, the arbiters of case law, and that's what controls as well. And a lot of people don't understand it. So we have to do a better job as members of the judiciary to showcase not only who we are, but what we do as well. You know, the Supreme Court has successfully utilized cameras in its courtroom for more than 10 years, and there's evidence to support the idea that more transparent courts will help educate our citizens about what judges do. So I am a firm believer in having cameras in the courtroom and having the public in the courtroom. It's extremely important. Should Ohio centralize and expand civic education in the law? Should there be a statewide web-based repository for judicial candidate information and a formal body for conducting judicial debates? You know, should we have more cameras in the courtroom? These are all topics that go towards educating citizens so that they will participate, and they will participate meaningfully in our elections. Because it's no good to have more people participating if they're still voting the same way and not really paying attention to how they form those very, very important decisions. Who should be a member of the judiciary? Should Ohio remain the only state in the union that holds partisan primaries followed by nonpartisan general elections for judges? And this is probably one of the more controversial ideas that is part of this discussion. 22 states elect their judges in competitive elections. 7 hold elections where candidates' party affiliation appears both on the primary ballot and on the general ballot. 14 have nonpartisan elections where the party affiliation does not even appear on the ballot. Ohio is the only state that holds an overtly partisan primary with ostensibly nonpartisan general elections. The question, should party affiliation have any bearing on races for an office that requires absolute impartiality? It doesn't make sense to focus on your political affiliation if, when you get to the bench, you are not supposed to be affected by, you know, party or any other special interest that is you have to leave all that stuff at the door as a judge. And the lawyers and the judges understand that. If you ask litigators, they will tell you they just want a fair, impartial judge. They don't care if it's a Republican, a Democrat, an independent. They don't care what the party affiliation is. And that's what's important. Now, is it time for Ohio to join the other states that have abandoned party affiliation in judicial elections altogether? That's a topic that you can weigh in on. And I'll tell you in a little bit how you can do that. Some scholars and other observers have argued that party affiliation is a valuable cue for voters, particularly in low information races like judicial races. Well, my response to that is let's cure the low information problem by disseminating much more information about the judiciary, making the judges much more visible, and bringing people together to understand what the judiciary does. And I think that that will negate the rationale that it's a low interest and low information race. We have to heighten that information. And, your party affiliation may give some people a cue, but I think it's a miscue because you're emphasizing that there's some relationship between your political affiliation and the way you do your job as a judge. And if that's the case, you don't belong on the bench, quite frankly. If you're going to let your partisan politics affect how you do your job, you don't belong on the bench. So, party affiliation has no place in judicial elections, and I could go on, but I think you get my idea on that one. So, the fifth question, should Ohio join the other states that have a formal nonpartisan system for recommending nominees to the governor to fill judicial vacancies? As I said earlier, more than half of the judges first take the bench by appointment to fill a vacancy rather than through an election. That's how I became a judge in Summit County when I was on the Court of Common Pleas. I filled a vacancy because of a retired judge. 36 states have some type of formal system to bring together citizens from diverse backgrounds to carefully consider candidates for judicial office. Ohio has experimented with nominating commissions with varying degrees of success in the past. Cleveland is fortunate that Cuyahoga County has a successful program for filling this function. And I talk about it all the time around the state. I talk about the bipartisan group that will make a recommendation, that will recommend candidates as either suitable for a nomination or maybe a candidate that is not suitable but potentially could be, and it's almost like a coaching session for them. To the credit of both chairs, both the Democratic and the Republican chair of Cuyahoga County, and I think Rob's here, and I don't know if Stu's here or not, but the governors have agreed to this, and this is a wonderful opportunity. Both Governor Strickland and Governor Kasich respect the nomination process that is utilized by the parties in Cuyahoga County. The chairs have agreed not to send a name to the governor that has not been deemed recommended or qualified. Qualified is maybe the better term. Qualified by this bipartisan screening committee, and they've stuck to their promise on that. And I think it's a wonderful system, and I think it should be duplicated in our major counties, in Ohio. It wouldn't work for all counties, especially the counties that have just maybe 15 lawyers in it. That may be a problem because there are many counties like that. But for counties that are comparable, I think it's a great formula, and it's a wonderful success story. Now, the American Bar Association has advocated this approach. Should Ohio adopt in law judicial nominating commissions for gubernatorial appointments? The larger issue at work here is direct accountability to voters, especially when you consider the significant number of judges that run unopposed in elections. In fact, as I said, in November's election, twice as many folks on the bench were unopposed as who had opposition. That's an important concept to grasp. The sixth question, should appointments to the Ohio Supreme Court require the advice and consent of the Ohio Senate? In the federal system and in a handful of states, judicial appointments by the chief executive, the president, or the governor must be confirmed by the Senate. And you think about it, you're putting folks on the top bench of the state, the Supreme Court, and why wouldn't you want the two other branches of government to weigh in on that appointment? It makes a lot of sense to have the governor with the advice of Senate, and it works, and it works in these other jurisdictions. Ohio, from 1803 until 1851, the rule was that the legislature was the sole body that appointed the judiciary. And of course, that must have raised some issues and some problems because they changed it and gave the constitutional authority to the governor to do that. Now, given the volume of appointments that are made each year, it's impractical to have this requirement for all judicial appointments, but it certainly makes sense for the Supreme Court. You know, that body exercises superintendent's authority over the entire court system. should the Ohio Senate have the authority to approve appointments to the Ohio Supreme Court. And of course, it would be based on the presumption that the nominee of the governor is qualified and presumed to be the selection. And the criticism here is, well, look what happens on the federal level, that you've got, this bottleneck, that we have so many unfulfilled seats. And my response to that is, shame on us if we can't do a better job than the feds. I think that we can here in Ohio. I think that we can fashion a system that may be modeled somewhat on what we have on the federal level, but we can make it Ohio's, and we can give the opportunity, a limited opportunity for the Senate to weigh in and have some guidelines and some, a window of opportunity as opposed to an open-ended opportunity that continues in stalls and ineffectiveness like they have on the federal level. We can do better in Ohio, and I know that we have the capacity to do that. So that's question number 6. Question number 7, should Ohio increase the basic qualifications for serving as a judge? Right now, if you are admitted to the bar, 6 years later, you could theoretically be Chief Justice of the Ohio Supreme Court. That's actually, I kind of maybe want my next opponent to have only 6 years. Maybe I should, not look at this one. But anyway. Another recommendation over the years has been to increase the number of years of practice necessary to be appointed or to run for a judgeship, and that makes sense. As I said, 6 years is the current amount of time. Across the United States, there's varying degrees of requirement. There is a state that has no requirements, so you could pass the bar, be admitted to the practice, and then you could, put your name on the ballot for judge the following, whenever, the following election is. And then some states have 10 years where you have to be a member of the bar for 10 years before you think about running for judge. I think that it's important that we talk about this. We talk about the benefits of having a more experienced judiciary, and you get your experience from the practice of law. And whether you're a government attorney, whether you're in private practice, whether you are, have clerking experience, which I think is a great experience for a member of the judiciary, whether you come from the prosecutor's office, from the public defender's office, the more experience you can bring to the job, the more you can add to the job. And I think that that's what is extremely important. There has been recent legislative proposals that would have implemented longer years of practice requirements, from 6 years to the Muni Court to 12 years to be a justice on the Supreme Court. I don't have a formula. I don't have exact number of years that I would recommend, but I would think that collective minds could come together for the best number of years for that formula. Now, the last question, should Ohio increase the length of judges' terms? Right now, every judge in the state runs every 6 years. This reform recommendation seeks to promote judicial independence while ensuring continued accountability to the public. The public does not want to see their judges be political, and yet every 6 years, a judge has to go out and put on a political hat and seek votes. And they have to do it in very similar ways to every other candidate that is out there. They've got to raise money. They've got to, talk about themselves. They're in some ways, some judges are very limited in what they can say. But it is a political persona that you have to adopt every 6 years while you're running, and then you have to completely disavow that for the rest of the time. And it's kind of some people have described it as a very schizophrenic existence. And so why not have a longer period of time, a longer interval before, if we're going to retain elections, and as I said, we are, let's not make judges have to do that so often. So they have more time to be on the bench, more time, and less time where they have to spend, being the politician that it takes to get elected in this state. And, I think that those in a nutshell are the 8 questions that I'd like some input on, and they emphasize again that each of this plan is phrased as a question. I don't claim to have all the answers. I believe the public can contribute, and I would direct you to ohiocourts2013.org, and that is the website. You can find much more information that I've been able to give you in this limited time. There's a very lengthy white paper. There's the opportunity to interact and comment. Your comments can be either anonymous or you can identify yourself, but I would urge you to go to ohiocourts2013.org for your participation, and we will read everything that everybody has said. There's been great participation thus far. So thank you very much. Thank you.
Today at the City Club of Cleveland, we're listening to a forum featuring the Honorable Maureen O'Connor, Chief Justice of the Ohio Supreme Court. We will return to the Chief Justice in a moment for our traditional City Club question and answer period. Please go ahead and formulate your questions now, and remember to keep them brief if you would. We welcome all of you here and those joining us via broadcast on WVIZ PBS, 90.3 WCPN, and 104.9 WCLV Idea Stream, WTAM, or one of our many broadcast partners all across the country. Broadcasts of the City Club are made possible by Cleveland State University and PNC. Our live webcast is supported by the University of Akron. There are many great programs taking place at the City Club in September, including Gail McGovern, CEO of the American Red Cross, the Cleveland mayoral debate, former Senator Olympia Snow, and the State of the Schools with Cleveland Metropolitan School District CEO Eric Gordon. Please visit our website, cityclub.org, for more information about our upcoming forums and to make a reservation, or you can order a CD or DVD of one of our programs. We welcome guests today at tables hosted by Baker Hostetler, the Ohio Lakefront Group, and the Tuesday Tumblers. Thank you for your support. Now we'd like to return to the Chief Justice for our traditional City Club question and answer period. We welcome questions from all of you. Holding the microphones today, we have City Club Development Associate Mike Cromaldi and volunteer Spencer Casel. First question, please.
Yes, Your Honor. Thank you for an enlightening talk today. On the lengthening the terms of judgeships, would that be a legislative issue, or would that have to have the Constitution change for that?
We could do that statutorily, and that's a good point. Thank you for bringing up that some of these changes do require a constitutional change. For example, going to the odd year for elections would be constitutional. The qualifications for the judiciary, the lengthening of the terms, that could be done statutorily. So this is kind of a mixed bag of what it would take in order to accomplish some of these, suggested reforms, which, by indication is that it's going to take some time. So this conversation is starting. Do I expect it to happen overnight? No, just because of the political process that will be necessary to effect. But the sequence, as far as I'm concerned, is to engage the public and to educate the public about the need, to educate the legislators about the need, and hopefully the public will also weigh in with their legislators. And then if there's a need for a constitutional reform, that comes from the legislature, and then it's on the ballot in the appropriate year. I'll be very honest with you. The other way to get it on the ballot would be to collect signatures, hundreds of thousands of signatures, and I'm not committed to doing that. I just don't have the organization to do that, and so that wouldn't happen. It has to be a grassroots with the legislature. Thank you.
Your Honor, good to have you here in Cleveland today. Good to
Thanks,
see
Rob.
you. A question, and not a criticism, but answering a question with a question. Question 2 and question 3. Question 2, should all judicial elections be in odd-numbered years? But then question 3, the low turnout, the low awareness of judicial elections. If we already know we have lower turnout in odd-numbered years.
Yes.
If we move the judicial elections, do we just end up with less of the electorate deciding because fewer turning out, or do you think it's an opportunity for what you talk about in question 3 to educate, utilize the more high-profile judicial races to get greater turnout, greater involvement?
It's the latter. I do believe that we can educate the public, and I acknowledge your point, and it's well taken, that there is a lower voter turnout in the odd years. And as I said, this process is not going to happen overnight from the, implementation of some of the recommendations and then the desired goal, which is to get high voter participation and high voter knowledge to go along with that participation. This is an evolutionary process. And I do believe that we can educate the public, we can excite the public about voting for the judiciary, because it is so essential, it is so important. Why does it matter who our judges are? Well, if you've been through a domestic relations case, you know how important deciding who gets custody and all the other decisions that are made in a domestic relations case. A juvenile case, if you've had, any relative or a neighbor or whomever where a child has to go to the juvenile court, you know how important and how those decisions implement the very fabric of or impact the very fabric of our society. Common pleas court, who handles the criminal cases and what kind of sentences are being handed out? The judges that weigh in on policy decisions. These are just so vitally important. And probate, that's very, if you want to, be able to live your life well, but you want to be able to pass on your belongings and your wealth to those who you deem worthy of having it. And that's a probate issue, not to mention adoptions in the probate court, termination of parental rights in both probate and juvenile. These are so important decisions that are just part of the fabric of a community, and you need qualified people to make those decisions, people you have confidence in. And so if we can educate voters about the importance of the judiciary, get them excited about learning about the candidates for the judiciary, I believe that their participation in the elections will also increase. Just because it's difficult doesn't mean we can't get it done. I gave this presentation to the Ohio Constitutional Commission, Constitutional Reform Commission a couple weeks ago, and somebody in the audience, a political science professor, said, "You're such an idealist to come up with," and I said, a girl can dream, can't she? I just think it's so important, and we have to start someplace. And just because it's tough, just because it's, it's going to take a lot of work, doesn't mean we don't do it.
Thank you so much, Justice O'Connor, for being here. And there's no denying what you've just said of how important the judicial system is in the country, in Ohio. I'm also idealistic, but I am somewhat pessimistic about the political will to make these changes. You said 40% of Cuyahoga County voters did not vote down the ticket for judicial elections in 2008, despite the fact...
2012.
2012,
Oh.
Despite the fact that we had 2 common pleas judges have federal indictments against them. So despite that terrible situation, there was not the excitement and the desire to make the change for the political, and have the political will to make these changes necessary. The reason I bring that up is because, for my question, yes, some of the changes you've indicated require statutory changes, which require the political process, but some of them, such as the statewide voter guide, which sounds like such a great idea,
Right.
I assume does not.
You're correct.
And-
that's
and-
something that I can do, on the Supreme Court, and as long as there's participation by the candidates, that's the important, to get the candidates to give the information, to fill it out and become part of that guide.
Well, my question is, how can the justices of the Supreme Court, or what is the official body, just to start that process? Because I assume once you put it in place, candidates would want to be on it if it was...
Sure.
So what is the process that you envision, or what's the status
It would
of that
just
right
be,
now?
an internal administrative decision by the court that we could do that. It doesn't take, statutory change. That it would be, I would certainly look to my colleagues for their input on the wisdom of doing it, and I cannot see a downside in any respect to having that done. It's a great starting point for the research that's necessary to determine, what candidate would be worthy of your vote. And that's what it's all about. What candidate is worthy of your trust, your confidence, which translates into your vote?
Chief Justice O'Connor, thank you so much for taking on a terribly important subject, and I agree with you that the people of Ohio probably aren't going to give up their right to vote on judges anytime soon. But in many of the smaller counties, you have one judge running in an election. And folks generally know that person and probably knew them as a lawyer when they were practicing. Here in Cuyahoga County, in our easier years, we probably have 17 judicial races. And folks tend not to know the judges or the candidates for judge. And many familiar names repeat themselves on the ballot. I've thought that it might be good if we could find something closer to a single-member district where we had one or two judges running in a district in any given election, so they're a little closer to the voters, a little better known by the voters. Whether we did that, for example, by doing it by Senate district or House district or some other method. Some states have departments per se. But if we break it up into a more manageable thing that people could look at and concentrate on a few judges, I think that would be terribly helpful.
And that's a very valid model that you're talking about. There's many states that do have regional judges. They have regional judges for the Supreme Court, where you're elected by a region of the state, and then you come together and you all, are all justices on the court. But there's many different models out there for the selection of the judiciary. It just so happens that in Ohio, there's never been an impetus to go to compartmentalize where you'll say, let's pick a big suburb like Parma. Parma's a pretty, well-populated. I think it might be one of the biggest suburbs I think it is the biggest suburb in the state of Ohio. Would you think that you wanted to just elect common pleas court judges, maybe 3 common pleas court judges from Parma to serve the entire the county? And that's what you're talking about. Maybe 3 judges from the east side of Cleveland. With 34 judges on the Common Pleas Court, is that correct? You'd still have quite a number of judges for each region, and I don't know whether, that would obviously be a decision that the voters would have to make. I'm not so sure that would be popular with them, but I do think that it's something that can be discussed. As I said, these are ideas that I'm putting out there, and I'm willing to consider the ideas and carry those messages to the legislature. We came up with this idea, but geez, all these citizens weighed in and they thought this was a great idea, and this is something that the legislature. So if there's a movement to regionalize judges in the state, that's on the table for discussion as well. I don't have all the answers, as I said, but that would be a really big departure from the way we elect judges now.
Okay.
Given the restrictions on commentary on specific cases or specific scenarios, you'd mentioned debates, and there's also some implication that maybe the guidebook would have some indication of the judges or the candidates' positions. Is that really feasible given the ethical restrictions on commentary, which brings us back to the other flag is your partisan affiliation? Can you really come up with an alternative?
Well, I didn't mean to suggest that there would be positions taken on particular topics in this candidates. That's not appropriate because obviously that is violative of the rule that a judge cannot announce how they're going to vote on a particular case. And if you do announce, there's grounds for recusal and an affidavit of disqualification. So no, that's definitely not what I'm advocating here. But if you're looking at questionnaires, and believe me, over the years, I have probably filled out 1,000 questionnaires. And there are some very valid questions that can be asked of the judiciary, and there's some totally invalid questions that groups present to the judiciary, judicial candidates. And you just have to be able to come up with a repository of information that has information in it that is within the, the canons and also gives information. Now, you mentioned that judges are precluded from talking about, and certainly I can't talk about a pending case or a case likely to come before the court. No judge can do that. But I can talk about cases I've ruled on and where I have, talk about my record. If I'm a candidate, if it's an open seat and neither candidate is a judge, they can talk about their record in private practice and why it matters to the voters because they've done X, Y, and Z, and that makes them the better candidate for the judiciary. That information is perfectly acceptable to put out there. And that's relevant and it's important. And it's more relevant and more important than what your political party is. Because as I said, it is a cue, but it's a miscue. Thank you.
Hold it, okay. Hi, Chief Justice. Welcome to Cleveland.
Thank you.
A question about qualifying judges. In some countries outside in Europe and the Middle East, there is a process before the judge become a judge to take a test or to be qualified by a certain entity before he get appointed again. Is that something that you are, at least to give to the public more choice about qualifying people who run for a bench? Is this something that you could you consider, or something that's up to that nature by the Chief Justice or the Supreme Court qualifying people to be in a judge? Thank you.
That's an excellent question, and the question has to do with how do you prepare to be a judge and what's relevant to that preparation. And it is true in European countries and many other countries, it's an appointed system, for one. There's a very big distinction between the ministerial role of a judge and the constitutional court role of other judges being on a constitutional court. And judges are educated in those countries from the time they leave high school. They don't have the same model that we do of 4 years of college and then 3 years of law school and then passing the bar, etc. There's an education system where they are aiming to become a judge, and they are then appointed by the government in order to be a judge. They don't stand for election. We don't have that comparable system here. So to have a lawyer choose a path, or college graduate choose the path that I want to be a judge or I want to be a lawyer, I think the value of private practice is so important, or public service, or your legal experience, that I wouldn't advocate for just an academic approach to becoming a judge, not here in the United States, certainly not in Ohio. But having said that, we have the Judicial College, which is an institution at the Supreme Court that puts on courses for continuing education for the judiciary. One of my proposals is to have courses available to lawyers that are interested at some point in their career to become a judge. And it wouldn't be mandatory, because I don't believe in, forcing people to do things. It wouldn't be mandatory, but there would be opportunities for education so that as a lawyer, if I decide that I want to be a judge maybe in 4 years, I'm, long-range planning, I'll take this course and that course, and that'll help me prepare to be a judge, and I can talk about that, with the voters, so they know that I've gone beyond law school and beyond the average, CLEs, and I've actually been planning for this and educating myself to be a member of the judiciary. And we would have to put together, course structure and material for that, but that's something that a lot of people are very interested in doing, and I'm very interested in having that opportunity. Last summer, I was at the University of Haifa with many judges from Eastern Europe and other parts of the world for a 3-week symposium, and I got to see the ministerial judges of these that are the products of this educational system. Many of those judges were 23, 24 years old, and they were they did their job by the book, literally. They referenced a book in order to tell them how to do their job. In other words, they look for what the offense is or what the situation is. They go to the book to find out what the solution is. They apply that solution, and there's not a whole lot of discretion. And that's what I mean when I say they're ministerial judicial entities. we don't need, I mean, we can't have that in the United States. We're a totally different culture, and I think a freer culture to be able to do that.
Excuse me if we're taking so long to get up. I'm very appreciative, Justice O'Connor, of the task that you're taking on in terms of trying to improve the judicial election system. I'm out of my depth here because I'm not an attorney and I don't follow the judiciary very much. But it has seemed to me that I recall that your elections have been some of the most partisanized, I guess, in my recent memory. And I presume that stems from partisan concerns about the Supreme Court or just concerns about decisions of partisanship in the Supreme Court. And I'm just wondering if we can ever get rid of the politics in the Supreme Court, even if we do the others.
And thank you for that question. The one premise that you're operating on that I don't think is founded is the label of partisan to interest groups. I don't think that, you know, when I think of partisan, I think of political partisanship, and that's what I'm talking about, eliminating, you know, the influence of political partisanship. There are folks that, you know, we have the elected system. There are groups and individuals and entities that support a candidate for the judiciary because they believe in that candidate's judicial philosophy. If it is a candidate for re-election, they look at the record of that candidate and the cases, and I'm talking about the Supreme Court, the cases and their voting record. I know for a fact our voting records are scrutinized by groups that are very much interested in the decisions that we put out. Their support follows the judicial philosophy of the candidate and the performance of the candidate in their job. I don't believe it's fair to say a judge changes their judicial philosophy and their votes to accommodate supporters. And that's the decision, that's the difference, I think, that I'd like to emphasize. Because I can tell you, for as many years as I've been on the bench, and we have a conference where there are the members of the Supreme Court sitting around the conference table talking about cases, never once has it been suggested, well, let's see what this political group or this special interest group wants us to do, and let's vote accordingly, or let's vote against it. That's not part of the discussion. It certainly isn't. And I would really ask that you read the opinions, or anyone read our opinions, and you will find there's plenty of opinions that I dissent on, that I have dissented on over the years. But I don't dissent because I believe that there's a political infiltration or a partisan infiltration. It's because I don't believe that the law is interpreted and applied to the facts in the correct way. And that's what the disagreement might be. And that is how many people decide who they're going to vote for or support on the Supreme Court. And I also want to maybe emphasize here something. I don't want to give the misimpression. Political parties have the right to participate in support candidates, whether it's from the president down to the judiciary. I am not precluding or saying that we should preclude political involvement. You know, you couldn't, even if you wanted to. And it would be an infringement on free speech if I would have said, you know, if I would advocate no Democrat and no Republican entity can support or work against a candidate. I'm not suggesting that whatsoever. But I don't think that there's a nexus between how a judge does their job and the fact that they were supported by this organization or this political party or that political party. I think that there has been some misinformation that really besmirches the judiciary of this state and this country, and from the United States Supreme Court down to the lowest courts. And I think that's unfounded and unfair.
Yes, this question has to do with the partisan primary versus nonpartisan general election. Is your thought, and maybe following up on this, is that the primaries, that there would be some kind of wall or some way that it would not become that one political party could try to dominate or one political party dominate the primary. In Cuyahoga County, knowing the numbers, this may end up that you would have 2 Democratic endorsed candidates for every single judgeship. And one of the things that kind of gives the ability to have a choice might be to keep the political parties even further out of it, quite frankly, through the endorsements or through the money spent. If one political party has much more money than the other, that again may have an effect on that primary, such that it might have the adverse or the inverse effect of making whichever is the stronger political party having every judgeship and every place for a judgeship. So is your suggestion to create a little bit more of a wall between political support, or?
No, not really.
No.
My suggestion is that, I mean, what's out there for discussion is that you're absolutely right. At a primary, the 2 top vote getters would have to face off in November. And they could be 2 Democrats, 2 Republicans, 1 of each, or a nonpartisan candidate. So there is no rule, because that's exactly what we have now, is that, one's going to be a Democrat and one's going to be a Republican. And that emphasizes the importance of having a Democrat or a Republican, and that's not the goal. And I will be very upfront and admit that idea is the least popular, especially with the political parties. So I joke and say, well, then there must be some merit to it. But I understand that is in some people's minds very problematic. Thank you.
Today at the City Club of Cleveland, we've been listening to a Friday forum featuring Maureen O'Connor, Chief Justice of the Ohio Supreme Court. Thank you, Chief Justice. Thank you, ladies and gentlemen. This forum is now adjourned.